Okay, welcome everybody to this webinar this afternoon. Before I start, I'll briefly introduce myself. My name is Salima Sammani, and I run my own law firm out through the Ethos Law on Granville Street. I mainly practice family and child protection law. I do a lot of legal aid, and I also run the Jane Doe Clinic, which runs out of Pivot. So today I'm going to be talking to you about the Family Law Act, and I've kept this webinar without lots of section numbers and a lot of jargon because I want to help make sure everyone understands what's going on without too much detail. And this the Family Law Act is quite long, so I've tried to condense it into bite-sized pieces. So I look forward to taking your questions either on chat during or after. So I'll just start and launch in. So the topics we're going to be covering during this webinar are the 5 W's of the Family Law Act. So briefly introduce you to what the Family Law Act is. I'll then be running through guardianship because that can sometimes trip people up, what that means and how you get it. Parenting time and parenting responsibilities, family violence and protection orders. I'll run through very quickly through FMEP, social assistance, family law agreements, what common law marriage is. I got loads of questions about that. And when you go with your family law issues to provincial court versus Supreme Court. Okay, to start, what is the Family Law Act? Well, the Family Law Act, and I'm going to be calling it the FLA, it replaces the old Family Relations Act, and that act came into place in the 1970s. So we're long overdue for a new act. The Family Law Act just came in a few months ago on March 18th, 2013. So expect lots of discussion about what the different provisions mean, how they're being interpreted through case law, and there's lots of dynamic things happening in the courts right now with the new provisions. FLA is a provincial piece of legislation, so it only applies in BC. Each province will have their own family legislation. The FLA applies to any family dispute that arises after March 18th, even if the spouse is separated before the Family Law Act came into force. And why was there a decision made to bring in this new comprehensive act? And that's because the FLA wanted to promote out-of-court settlements. It is a child-centered piece of legislation. It provides a definition of family violence, and it is more in line with family legislation in other provinces. So first I'm going to start talking about parenting time and parenting responsibilities. Now that's the meat and potatoes of parenting, and what that means is under the old act, guardians sought to divide time with the child and decision-making regarding children using terms such as custody, access, and guardianship, so the meat and potatoes. But now the terms we'll be using people will be using are to divide parenting time and parenting responsibilities. So the old custody and access terms are out the window. They're not used anymore. They are used under the Divorce Act, but not under the Family Law Act, and guardianship has a bit of a different meaning. So parenting time and parenting responsibilities, that's the new lingo. So how do you get parenting time and parenting responsibilities? Well, first, let's talk about what parenting responsibilities are. So I've listed everything that's considered a parenting responsibility. I won't go through every single one, as you can read the bullets and they're found under the Act, but it's everything from making the day-to-day decisions that affect the child, so day-to-day control and supervision, deciding where the child will live, who they'll associate with, their extracurriculars, anything about their cultural, religious, and spiritual upbringing, whether to give consent on different medical or dental procedures, applying for a passport, withdrawing consent, all things like that. So as you can see, it's basically anything to do with parenting decisions about a child is called a parenting responsibility. So then the second thing to be divided up is parenting time. And parenting time is any time that a guardian has with a child. So you've got two things to be divided up when it comes to children. You got parenting time and parenting responsibility. The custody, the access, all that is gone. And so you know that during parenting time, the guardian who has the parenting time gets the responsibility of making day-to-day decisions. So that's minor decision making. So when you're a parent, when you're a guardian and you have your parenting time, you may not have day-to-day decision making allotted to you globally under an order or agreement, but during the time that you're exercising your parenting time, you will be able to make day-to-day decisions. So here we get to the big question then, how do you get at these two things, parenting time and parenting responsibilities? Well, you have to be a guardian, period. That's it. Only guardians have parenting time and parenting responsibilities, no exceptions. So to get at the parenting time and parenting responsibilities, you got to be a guardian, and how do you become a guardian? So a guardian is a parent who has lived with the child, a parent who has never resided with the child but regularly cares for the child, a parent who has never resided with the child but all of the guardians make an agreement that they are a guardian, a parent under Section 30 parentage agreement, and a parent who is not a guardian, a person who's not a parent but appointed as a guardian by an order of the court. So I'm going to run through an example of what all those are. So parent who lives with the child, so that's a birth mom. She gives birth to the child. She's the parent. She's lived with the child since the child was born. She's a guardian. So parent who has never lived with the child, say dad, mom and dad, they're the two parents. They've never lived with the child. The dad's never lived with the child. He lives in another residence, but he takes the child every, say, Monday, Wednesday, Friday. He's involved in all the decision making. Even though he's never lived with the child, he's still a guardian. Then there's also if you've got a parent who's never lived with a child and, comes out of the woodwork, say, 5-7 years later, says, hey, I want to be in this child's life. I'm the biological parent. The guardian can make an agreement saying, you're a parent, you get to be a guardian. Now, parentage has to do with in vitro fertilization, that type of things. If you find yourself in that situation, trying to determine if you are a guardian or not, you're probably well advised to go see a lawyer. And the last one is a person who's not a parent but appointed as a guardian by the court. So people who are not parents, say grandma, uncle, step-parent, can apply to the court to become a guardian. So all these people that you see listed in front of you here, all the examples I gave you, if you're a guardian, you get parenting time and parenting responsibilities. If you are not falling under one of these categories, so you're not a guardian, you do not get parenting time and parenting responsibilities. And just to be really clear, I want to make sure everyone knows what does it mean to be a parent. So the parents of the child are presumed to be the birth mother and the biological father. So when I talked about parentage, that's what I meant when I said in some cases parents can be donors, surrogate moms, intended parents, and this is all dealing with assisted reproduction and surrogacy. And to be clear again, a step-parent is not a parent. So step-parents lived with a child since the day they were born. They are not a parent. So they are not a guardian automatically, even if they've lived with the child. They're someone who's going to have to apply for guardianship. So here I have an example where a parent who takes off to Australia after the child is born or while the mother is pregnant is not heard from for several years. That parent is not a guardian and not entitled to parenting time or parenting responsibilities unless all the guardians and the parent who took off make an agreement that that person is a guardian. So yes, you are going to find situations where someone is a parent, their biological dad, never lived with a parent, haven't regularly cared for a child, haven't heard from them for, a few years maybe, and they come back in, and they're going to be treated just like basically a perfect stranger in terms of allotting them parenting time and parenting responsibilities. As you can remember, parenting responsibilities is really the meat and potatoes of what it is to raise a child. And now to kind of give you guys a heads up on what's happening with that and how dynamic this new Family Law Act is because it is so new, is that there is a charter challenge that has been raised, and who knows, it was just raised about 3 days ago, I think, that, this is against the rights of fathers because they're being discriminated against because they can be kept away from the child if the mother so decides, and then they are not guardians. So stay tuned for an update on how that goes. But for now, we are in a situation where a biological parent who has not lived with the child or regularly cared for the child, or there's no agreement, is not a guardian and is going to be treated exactly like a stranger would be treated in terms of applying for parenting time and parenting responsibilities. So to, again, put it another way, not all parents are guardians, and not all parents are entitled to parenting time and parenting responsibilities. So this begs the question, if a parent is not a guardian and all the guardians do not agree that the parent should become a guardian, so dad's gone off to, parent's gone off to Australia, never seen the child, never had anything to do with the child, comes back and says, hey, I want to be a guardian. Mom says, no way, not going to happen. What then? Well, that parent can then apply in court to become a parent. This is not an easy process. There's all kinds of things that happen. There has to be an MCSD check, a criminal record check. They have to show that it's in the best interest of the child for this person to become a guardian. It is a long process. Again, this is a very new process. We don't have a lot of decisions that have come down either way where a parent has been denied or accepted. It's only been, like 12 weeks now, I think. So stay tuned to see how that plays out. So then the next logical question is, well, can someone who's not a parent become a guardian? Well, so now we're talking about, grandma, uncle, step-parent. So a person who is not a parent can become a guardian by applying to the court. And unlike when you have a parent who has taken off and then come back and said, I want to be a guardian, where the two guardians or any guardian that exists can make an agreement that this parent can become a guardian. When you have a non-parent, guardians cannot make an agreement that this non-parent become a guardian except if it's under the Adoption Act or the CFCSA. So an example to bring this to life is that two guardians, two biological parents, say, this example, cannot make an agreement that uncle, sister, grandma is a guardian unless, again, under the Adoption Act or the CFCSA. So this leads to, another example where stepmom and dad may not be a guardian even if they've lived with the child since birth. So I recently had a case where a gentleman moved in with mom while she was pregnant, not his child. He's been, raising the child since she was born. This gentleman and mom had another child. He's the guardian of child 2. He's not the guardian of child 1, so they recently split. He got parenting time and parenting responsibilities with child 2, has to pay child support for both children, but he is not the guardian of child 1. So going back to if you've managed to become a guardian and you find yourself negotiating with the other parent for parenting time and parenting responsibilities, the meat and potatoes, what will the courts consider when allocating parenting time and parenting responsibilities? So what they're going to consider is the best interest of the child. That is the only consideration in assessing what parenting arrangements are appropriate for the child. Under the old Act, best interest of the child was a paramount consideration, but other considerations were relevant. But now it is the only consideration. So that takes me back to when I introduced why the FLA, came to be born, and one of its mandates is for it to be a child-centered piece of legislation. So this is really important, and I'll tell you later on why this child-centered best interest only test is really important when it comes to family violence. So when we want to look at what is the best interest of the child becomes obviously very important because it is the only consideration in determining how parenting time and parenting responsibilities will be allocated. So when we're looking at that, the best interest of the child will be the child's health and emotional well-being, the child's views, if it's appropriate to consider them, the history of the child's care, their need for stability. So here we're talking about not shifting children from home to home all the time, the ability of the guardian to exercise their responsibilities. And here we have the impact of family violence on the child's safety, security, and well-being. And we're going to talk more about that later when we get to the family violence piece of this webinar. But here you can see that family violence is being considered when we're talking about allocating family responsibility, the responsibilities and parenting time. Also, we're going to talk about when best interest of the child, they look at the person responsible for family violence and consider whether the person responsible for the family violence is going to be able to care for the child and meet the child's needs. And I really like this other one, this I, as you see there, is the appropriateness of an arrangement that would require the children's guardians to cooperate. So I see this all the time where parents can't just have terrible communication and they aren't able to agree on even the tiniest thing. And the courts are really going to look at that and say, it'd be nice if this was all 50-50 split and everyone could come together, but that's not the reality. And they're really going to take into consideration if it's appropriate to make a 50-50 split, if it means the child's constantly going to be in limbo about the decisions that involve the child. And the last one, again, which is really important, is any civil or criminal proceeding relevant to the child's safety. So this, again, is going to maybe bring in the issues about family violence when we talk later on about protection orders and how they have a criminal ramification now. So if you've got, a history of a parent breaching protection orders, and which has criminal consequences, that's going to be taken into consideration when thinking about what's in the best interest of the child in splitting parenting time and parenting responsibilities. And so the final catch-all here is no agreement or order is going to be in the best interest of the child unless it protects to the greatest extent possible the child's physical, psychological, emotional safety and security and well-being. So once again, in making our agreements and negotiating and making submissions to the court, we'll all have to be really mindful that everything we're submitting to the court or negotiating, whatever we come out with, it really is in the best interest of the child and is not going to be taking into consideration the convenience for the parties and things like that. Okay, so you're going to hear this term all the time, parenting arrangements, and I wanted to throw it out there so you know what it means. Pretty simple. All it means are parenting arrangements really are the provisions that split parenting responsibilities and parenting time. So when someone says, oh, well, we've got the parenting arrangements sorted out, what they're meaning to say is we split up or we've allocated the parenting responsibilities and parenting time. So that's all that is. It's just a little umbrella term that talks about parenting responsibilities and parenting time and how they're being separated. So one thing to note, that it is not presumed that parenting responsibilities should be allocated equally amongst guardians. So again, this goes back to the best interest of the child. There's no 50-50 presumption that it should all be 50-50 or anything like that. They're really going to, of course, put an emphasis on looking at the best interest of the child. Is it really reasonable? Is it going to be too destabilizing for the child to be shifting from house to house every other day or whatever it is. So there is no presumption. You sort of start with making your case, and I think that's really important because you're not fighting against this presumption. When you start making your case, you're building your case from scratch, and I think that's wonderful. Okay, so now we take you back. We've talked a lot about parenting time, parenting responsibilities. And we know that parenting time and parenting responsibilities only goes to guardians. And some of those guardians are going to be parents and some of them aren't if they've applied to the court. So what do people get that aren't guardians? So say stepdad or dad or mom that took off and didn't come back for many, many years and had nothing to do with the child. So what they get is contact. So grandma is a non-guardian. She does not get parenting time. She gets contact. Stepdad is allocated parenting time. Contact, not parenting time once the stepdad and the guardian are separated. Now, what's the difference? Does it matter? Yes, absolutely. Contact is not the same thing as parenting time. A person with contact does not have parenting responsibilities during their time with the child. So grandma, stepdad, in my case, the gentleman who raised the child from when she was in the womb until she's now, I think 12 years old. Now that him and the mom have separated, when he gets his visits with the child, he does not have any parenting responsibilities during this time. He cannot make any day-to-day decisions about the child. This all defaults back to the guardian, who is the mom. So there is a really big difference between a parenting time and contact, which is why, again, you see, I mentioned the charter cases coming down, is that they aren't one and the same thing. So if dad does come back and say, well, now I want to be in the parent's life, child's life, he's going to want to apply for guardianship. So he's actually got a say in the way the child is raised. So to recap, only guardians can have parenting time and parenting responsibilities. Not all parents are guardians. Not all guardians are parents. Non-guardians do not get parenting time, they get contact. During parenting time, you have parenting responsibilities. During contact, you do not have parenting responsibilities. There is no presumption that any particular split of parenting time and parenting responsibilities is in the best interest of the child. And the best interest of the child is the only consideration when determining guardianship, allocating parenting time and parenting responsibilities, and allocating contact. Okay, so we've gone through now guardianship and parenting time, again, the meat and potatoes of what it is to be a guardian. So now I'm going to move on to family violence and protection orders. As I mentioned in the beginning, the FLA focuses a lot on the impact of family violence on children and relationships. So before the FLA, there was no legislative consideration of what is family violence, especially in regards to best interest of the child. Now, though, we have a definition of family violence. This is wonderful. It gives us a baseline to work from. And the reason I've put this all in here in all its detail is because it's really important to see how comprehensive this definition of family violence is. It includes physical abuse, deprivation from the necessities of life, sexual abuse, attempts to physically or sexually abuse, psychological or emotional abuse. I see a lot of this where I see, hundreds of emails a day or dozens of text messages a day, just really things that terrify people, but sometimes they don't consider it abuse. And now we have this definition. This includes, harassment, unreasonable restrictions from financial or personal autonomy, stalking or following, damage to property. This next one I think is incredibly powerful. It's that in the case of a child, direct or indirect exposure to family violence. So a child who witnesses their parent being abused is considered to have suffered from family violence, or even if it's indirect exposure to family violence, seeing sort of the aftermath of family violence, can be considered family violence that this child has suffered. When we're talking about the best interest of the child, the courts are really going to consider family violence, and they're going to consider the nature and the seriousness of the family violence, how recently it's occurred, the frequency. They're going to consider whether the family violence was directed towards the child, and whether they were just exposed to it, even if they were not directed to the family violence wasn't directed at them. And any harm to the child's physical, psychological, and emotional safety as a result of the family violence. So there you can see that whole list of factors there. So then that begs the question, okay, my client or me, we fit into this definition of family violence. This is some of what we've suffered. What can you do then? Well, if you qualify as an at-risk family member, you can apply to the court for a protection order. Okay, so let's break that down into bite-sized pieces. And so what does that mean? So an at-risk family member means a person whose safety and security is or likely at risk from family violence carried out by a family member. Okay, so it doesn't have to be that you are being, abused right this second. It might mean that we know it's coming down the pipeline. And what does it mean to be a family member? So it can be a spouse, a former spouse, someone you're just living with in a marriage-like relationship, a parent or guardian, a relative. It includes a child. So you're at risk, a family member. You qualify to apply for a protection order. So here are some really interesting facts about protection orders. You can apply for protection order without applying for any other relief. So some of you might have helped your clients or yourselves have applied for protection orders in the past, or they were called restraining orders, I think, under the last act, is you would apply for that with something else. So you're applying for custody or access, one of those old terms. In that, you could have applied for a protection order or a restraining order. Now you can apply just for the protection order. And to those of you out there that are advocates, you may or may not know that legal aid now gives a 7-hour referral. So the referral for family case is much bigger. I think it's 20 hours, but depending on Supreme or provincial. But for protection orders, they'll give a 7-hour referral just for getting a protection order for a person. So do take advantage of this limited referral that legal aid will give for a protection order. The other thing to really remember here is protection orders expire in 1 year unless ordered otherwise. Now, this is unfortunate in that prior restraining orders did last, until they didn't anymore, if they were overturned or whatever, or varied. But now they expire in 1 year. So that does sort of pose a few problems in that you'll want to remember that. You'll want to remember to apply for them. You'll probably want to instruct your clients that although during the time when the protection order is in place, they might, hopefully there's no breaches, so they'll be safe. But around the time that that's expiring, to take a lot of care and start keeping records right away if they feel like the family violence may return, so they can go in there and apply for another protection order, because they're going to have to meet the test of that the family violence or a harm is present. So do advise them of that. This next fact I think is incredibly important is that breaches of protection orders are criminal offenses and can be enforced under Section 127 of the Criminal Code. So this is really important because before, breaches of the restraining orders were punishable under civil law under that FALE, but now they move into the criminal justice system. So there's very real and serious consequences for breaching a protection order. And that's a huge benefit to our clients that we deal with. It also does place the onus a little bit higher, I find, because there are some serious consequences for the breach that you're going to find that judges are going to perhaps be a little more reticent, require a little more documentation than they had before. So whether it be print off of the text, the emails, the police report to order these protection orders. And the next one for the advocates out there, the at-risk family member can apply themselves for a protection order. Also, a person on behalf of the at-risk family member can apply. So that to me means, the advocate, a family member. Or if the court sees that a protection order is necessary, they on their own initiative can take it upon themselves to apply or to invite in a protection order. So I think those are all really important facts to keep in mind about these protection orders because they are new. So what do the protection orders look like? Well, they can have provisions that restrict communication, have reporting requirements, ask that if a person who's the perpetrator of the family violence or the person whose order has been made against be removed from the family home if they're still there, can have a seizure of their weapons or firearms. They can do directions to police officers in these orders about what to do if the offending party is in violation of the order. And it can really be, I think, a bit creative in terms of additional terms the court deems necessary to protect the family member in their particular situation. So as I mentioned a few minutes ago, is that because of the very serious consequences of breaching a protection order, there are some factors that the courts are going to consider before making a protection order. And what they're going to look at, and these are sort of the checklist that when making the affidavits for my clients, I go through this checklist of risk factors to see what's there and really speak to them. So if you're in the position where you are going to court as an advocate with one of your clients or helping them draft an affidavit, you're going to want to look at these risk factors and speak to whichever ones apply. So you want to mention the history of family violence, whether the violence is repetitive or escalating. So, we know that emotional and psychological harm is looked at as family violence. So if you're seeing, over 5 years or 2 years, tons of text messages and emails, or getting someone's car towed every month for the last 6 months, you're going to want to mention that as, repetitive and escalating family violence. Whether the psychological or emotional abuse is a pattern of coercive and controlling behavior. And I like this one, which is if there's been a recent separation or intention to separate. I'm sure a lot of you who work with women in this situation have seen that during the time of the separation, when assets and family time is being divided, things like that, there is an escalation of family violence, and the court's going to look at that very seriously. So if you have a client who's saying, well, I want to separate, but every time I bring it up, there's just an escalation or there's lots of threats, this is the time to go and get the protection order and make this pitch to the judge that there is an intention to separate, and this is the time when we need the protection order. And I'm just going to finish up the criteria here. So they'll also look at any risk that increases the risk of a family member for violence. If that family member, is got some substance abuse issues, is unemployed, their mental health problems, their access to weapons, their history of violence, all these things are risk factors for someone who is the order is going to be made against. And this is one that I particularly like for my clients. It allows assessment and shows that they look at vulnerability, which includes pregnancy, age, family circumstances, health or economic dependence. So definitely speak to that in your affidavits or when you're speaking with the court. Now, looking at this, there is a comprehensive list of factors, and how many of these do you have to meet? There's no magic number. I think you just, whichever ones apply to you, and you make the strongest case you can for as many of them. Again, these are very new, these protection orders, so we haven't seen the court come down and say anything in terms of numbers. But when I do interview my clients for getting a protection order, I take a lot of time with them, maybe 2-3 hours with them. I send them off with their advocates sometimes because they have very long relationships with their advocates where I'm only given 7 hours to deal with getting the protection order. They've got these extensive relationships with their advocates. I send them off and say, why don't you look at these things and see if any of these apply to you, and spend a couple hours with your advocate. And there's a lot of back and forthing I do to make sure I get them a really deep and detailed and historical story about this at-risk family member. And in terms of, do you have to have a police report, or is the woman's or the person's account of the abuse good enough? Absolutely. The thing I tell women is often I have women in my office saying, but nobody saw, there's no evidence. And the thing I like to remind women of is you are the evidence. You're writing the affidavit. That's your evidence. You can go into the stand and testify if the judge requires you to do so. You are the evidence. You do not need everything else. Certainly, if there are police reports I do ask my clients to get those. I do tell my clients that call the police, make a report every time something happens. It's always nice to have those things to attach as an exhibit to the affidavit, but certainly you are the evidence. I try to instill as much confidence in my clients as I can that their word is good. So I'm going to recap here. So family violence includes psychological, emotional, physical, and sexual abuse. You can apply for a protection order on its own without applying for another family order. And for the advocates out there, remember about the 7-hour referral that's now given to for lawyers to help a woman or a person get a protection order. You can apply for a protection order ex parte. And what that means is that you do not need to notify the party against whom the order is being sought that you are getting the order. So if a woman comes to me and says, well, we're separating, I'm terrified of him, he's making all kinds of threats, I can make an urgent application to the court without notifying the person who we're getting an order against, draft up the affidavit, go in and try and get the order. Protection orders last for 1 year unless ordered otherwise by the court. We've unfortunately seen some protection orders come out that were 2 weeks long, and gosh, I have no idea why that would happen, but it has happened. We've seen that. Again, it's all brand new, so we're seeing all kinds of things. Haven't seen any ones come out that are greater than a year, but certainly I think there will be situations where the court will order these longer ones. Any breach of the protection order is a breach of the criminal code, and you, someone on your behalf, or the court can seek a protection order. Okay, so we've moved to guardianship and what it means to have family time and parenting time, and the family violence piece and how children are being considered in that. And one thing I did forget to mention is, I often get the question, well, from women I see that, I've been the subject of abuse, child has never been touched. Is that going to be considered when dividing up a parenting time, parenting responsibilities? And as you can see, certainly, and of course protection orders are also going to be considered when dividing up parenting time and parenting responsibilities. So I'm going to move quickly through this slide. This probably is old hat for a lot of you, but just in case, we're moving to more of the economic side here. So the Family Maintenance Enforcement Program is a government program that enforces child support or spousal support orders or agreements that are made between parents or spouses. So as long as the order or the agreement states amount the payer is required to pay, so remember, if you're coming to an agreement, even if it's a rough one that you're drafting up for your client, make sure you put the amount, make sure you put when every month is to be paid, so the July 1st, and whether that payment on July 1st is for June or for July, make sure you put that on there. They can file that with FMEP, and FMEP will enforce these orders or agreements. And as you may know, that if these arrears, so missed payments, are significant, FMEP has got very, very long arms. They're able to garnish wages, suspend driver's license, refuse to issue passports. They can do all kinds of things, and the service is free, so I certainly encourage your clients to take advantage of that. And there's the website link for those of you who need it. So I'm going to move to another topic as they're somewhat related. And so when we're talking about child support, if a parent is owed child support, but they receive social assistance, the parent who's supposed to be receiving the child support and is also receiving the social assistance will be required to sign over their right to pursue the child support to the government. So you're being owed $500 by the father, but you're getting social assistance. Father's not paying. Well, you'll continue to stay on social assistance. You'll be fine on that, but your right towards that social assistance will now be signed over to the government, who is then going to pursue this for you, and whatever monies they accrue, they'll keep. So this again doesn't cost you anything or the person anything who's receiving the social assistance, but that's something to certainly keep in mind. So moving to another topic about family law agreements. So and the reason I mention this in here is that agreements can be made about a lot of different things. Courts are starting to respect, under this new act, agreements a lot more, and it's going to be very difficult to overturn an agreement. And once an agreement is made, it can be filed in court, and it will be treated like it is an order of the court. So as you can see, agreements are going to be really significant. So it's important that our clients are advised to take these agreements very seriously. Often, we have clients come in and say, I just want them out of my life. They can have everything. I don't want anything. Certainly, we're best to serve our clients to say, take your time on that. Make an interim agreement, but don't make an agreement. Make an agreement that lasts a few weeks while we're negotiating this, or a few months even. So the thing to know about that is they are presumed to be binding unless under the Act you meet some criteria that the judge can say that the agreement is not binding. So if it's significantly unfair or something like that, but it's going to be a hard threshold to meet. And you can make an agreement at any time. So before you get married, when you're already living together, or even after. But these are the things to know about an agreement. An agreement respecting parenting arrangements, so how the child's parenting time and the parenting responsibilities and child support, is not binding if it's made while the family is still together or before the child was even born. What you're going to want to do is make these agreements respecting parenting arrangements and child support after separation, or when the parties are about to separate and the agreement is to take effect upon separation. And now the thing to know about child support is you have the child support guidelines. So the courts are going to take a very dim view to any parents who have agreed to child support below the guidelines. So please do note that be very careful when agreeing to child support. And agreement respecting parent agreements, as I said, that is followed the court, is enforceable under the Family Law Act, like it's an order of the court. And remember also, an agreement respecting child support, spousal support, can be filed with FMAP. So these agreements should be taken very seriously when made. Certainly it's best to see a lawyer, make sure you're on side with what you're agreeing to, and it is in your best long-term interest. Now, this is something that I get questions on at parties, everywhere I go, so I touch it in all the webinars and seminars I do. What is common law marriage? Okay, there is nothing like common law marriage. You are either married or you're not. If you live with someone long enough, the law does not consider that you are married to that person. What happens, though, is that if you live with someone in a marriage-like relationship for at least 2 years, you become spouses. So you're not married, you're not in a common law marriage, you're just spouses. And what that does, it triggers a division of assets just like if you're married. So as you may know, and this is, I say this in very generally, there is presumed to be an equal division of family assets and family liabilities or family debt. So once you are a spouse or you are married, you there's a triggering of that equal division. So hopefully that clears some things up for your clients who might be in a situation where they don't know where they stand, and if they have to get a common law marriage annulled, then there's lots of questions about what that looks like. And the next question I get asked a lot is supreme or provincial. So we all deal with a lot of people that have to go to court by themselves, unfortunately. And this is what people should keep in mind when they're deciding which court to apply into. So the Supreme and Provincial Court have jurisdiction over, both have jurisdiction over children, child support, spousal support, and protection orders. So they can go to either one of those. If they've got any of those issues, they can go to either court. And, you know, we have some questions about protection orders. Can women go themselves? You know, sometimes if it's an urgent situation, they might want to go to Supreme Court rather than provincial, because Supreme Court, you know, sits much more regularly than provincial court. So they're likely able to get into seeing a judge a bit quicker. So what will the provincial court not deal with? Well, the Supreme Court has exclusive jurisdiction over marriage, divorce, and division of property. So any property division issues, to apply for divorce, you must apply in Supreme Court. So if spouses need an order respecting the sale of the family home, they have to go to Supreme Court. At that point, if they've also got other issues about children, they might as well just apply for Supreme Court for really all of it and get it all done in one shot in one court rather than running parallel proceedings in two separate courts. And if two guardians want an order respecting parenting arrangements, they can apply to either the Supreme or the Provincial Court. Either will do. And there's different considerations in different courts, timing and things like that. So you'll certainly on each case want, if there's a lawyer available to advise you, you'll want to have a quick chat with them. So this brings me to the end of the presentation and leaves us some time for questions. So that's me, Salima Samnani, and this is where you can find me if you need to call me or anything. If you want to book any of you or your clients into the Jane Doe Clinic, please contact Pivot directly, and they have a DJ Larkin right now is who is booking my appointments. Please do call into her and make an appointment. Lastly, we want to thank the Law Foundation, the BC Society of Transition Houses, and Pivot for making this webinar possible.